I am Reverend Dr. Judith Moore. I am the founder and CEO of Sisters Saving Ourselves Now. We are a nonprofit organization that focuses on actionable steps for marginalized women of color, but more specifically, Black women. So we are so excited to be partnering with the Pennsylvania Modern Courts. And now I turn it over to my sister, Deborah, who will take it from here.
Thank you, Judith. I am very excited to be partnering with you. This is actually our second opportunity to partner together, and we look forward to many more. I am Deborah Gross. I am the CEO of Pennsylvanians for Modern Courts. It is also a 501c3 nonprofit. We were created, I will say, over 30 years ago as a result of a lack of confidence in the judiciary. Okay, there had been a number of scandals, and there had been some a task force commissioned, and the task force suggestion was that appellate court judges be chosen by merit or selected based on merit, because in Pennsylvania we elect our judges. That has not yet come to pass. I say yet, it's always something that we are looking towards and for, but in the interim, Pennsylvanians for Modern Courts is really dedicated to making sure that there is access to the courts, fair treatment in the court system, helping people represent themselves. And we have a series of programs through our PMC shares where we have workshops on various topics, one of which is landlord-tenant disputes. Our programming is throughout the Commonwealth, Pennsylvania. Today, we have the great fortune, I will say, to be joined by Magisterial District Judge Oscar Petite, who has also helped PMC do various workshops, including most recently one on the court basics. But this program is focused on landlord-tenant disputes, and it is particularly timely in light of the eviction moratorium, which will expire very shortly. And we wanted to make sure that we provide education and opportunity to answer questions of yours on the landlord-tenant dispute. So I'm going to allow, Michelle, do you want to move the slides forward? Can you? Okay, sorry. Keep going. Keep going. I breezed through this quickly. Okay, so Judge Petite, do you want, Judge Petite, you're in person, so I don't want to interrupt you. Maybe I'll pass the baton to you. And when, I'll butt in a few times just to ask some questions, maybe I'll make it to clarify, but I'm going to let you handle this because this is definitely in your wheelhouse. And I don't see you on the screen though.
Okay, can you hear me?
I can hear you, I just can't see you. That's fine.
We'll get Quentin to take a look at that so I can be seen as well. I'm going to remove my mask. I'm going to let everybody know I did have a mask on. Everybody in the room has a mask on, but we are socially distant. I'm Judge Oscar Petite Jr. I'm happy to be here today, particularly invited by Pennsylvanians for Modern Courts. We've done several of these workshops in the past, and we have a great working relationship. Also, the Pittsburgh-Mon Valley Black Women's Roundtable with Reverend Dr. Judith Moore. Jackie's here today. And just to tell you a little bit about the court system as it is established in Pennsylvania. As you can see up on the screen, we have various different courts. These are the courts that are outlined in the court of Pennsylvania. At the bottom are the municipal courts and the magisterial district courts. If anyone is ever going to have a court experience, more than likely it will be at that level. The next level after that is the common pleas court. That's our trial court. Decisions that are appealed from the magisterial district courts can eventually work their way to the trial courts. And from there, we have the intermediate level appellate courts, which consist of the Superior Court and the Commonwealth Court, and the Pennsylvania Supreme Court, which is the final arbiter in the state of Pennsylvania. Next slide.
So I don't know if there's a, Your Honor, can you see the slides?
And it's very tiny in the right-hand corner.
Yeah, that's what I'm wondering. I didn't think of that. So I guess I'll ask you a question. I mean, where do most landlord-tenant disputes end up? Or where do they initially arise? In which court do they first go to?
Well, the Magisterial district courts across the state of Pennsylvania, there are about 500 of us. In each district, yes, about 500, we're about 540. There's probably about 500 district courts. And I would say that of the 500 district courts, there are probably maybe 15 judges of color out of those 500. So all of those courts here, landlord and tenant matters. And we are the court that's at the bottom. It has been said sometimes we may hold up the entire court system with the number of cases that we get. But the landlord and tenant cases will begin at the Magisterial District Court. Let's talk a little bit about fundamental rights. Fundamental rights fall under the 14th Amendment to the United States and the Pennsylvania Constitution. Anything that involves a fundamental right requires two things, notice and hearing. Now, what's a fundamental right? Your right to move about freely in a criminal case is a fundamental right. That's why if you get arrested, you have to be arraigned, told what you're being charged with, a bond is set, then you have a court date. They have to tell you within a specified amount of time what your charges are and when you're going to be brought before a judge. In Pennsylvania and all courts, the courts do not close. 24 hours a day, the courts are open. Now, is having a roof over your head a fundamental right? It could be said that it is. That's why, in order to bring a landlord and tenant case, it requires two things: notice and a hearing. So, when we talk about the notices, there are 10-day notices, 15-day notices, and 30-day notices. Those are the things that have to be done procedurally before a landlord and tenant case can proceed into court. Now, let's talk about, you want me to talk about the examples of discrimination?
Sure, because I think that's, I think that's important in that people should know what their rights are as a tenant, right? There are certain rights, although I know right now what we're most concerned with is having a roof over our head, but there are some basic rights as to how landlords should treat tenants and potential tenants.
Okay, let's talk about that. Federal and Pennsylvania laws tell us that all individuals have rights not to be discriminated against when they are searching for housing. Discrimination: a landlord, real estate agent, or mortgage broker who refuses or changes the quality of service because of color, age, religion, national origin, sex, gender identity, sexual orientation, disability, or familial status. Housing discrimination is illegal. Instances of housing discrimination require the tenant to go to court. Instead, if a tenant feels that they have been discriminated against, they may file a complaint with the Department of Housing and Urban Development, that is HUD, or with the Pennsylvania Human Relations Commission. Let's talk about some examples of discrimination. The landlord says that the rent is higher than advertised after meeting the potential tenant in person. We know that happens. Sometimes people cannot recognize who you are by your voice, but once they see you in person, all of a sudden the story changes. So the landlord says that the rent is higher than it was advertised. That may be grounds to have that investigated to see if whether or not he or she is doing that to all potential tenants. The landlord does not allow full use of a home facilities because of race or color. Also, an advertisement states that a property is only available to people without children. Landlords cannot discriminate because you have children. And we know that landlords certainly, in some situations, may feel that children may cause damages to their property or things of that nature. but that they cannot discriminate against you because you have children. What other rights do tenants have? A landlord cannot do the following to a tenant: take or sell a tenant's property if they do not pay rent, shut off utilities or lock a tenant out of the property if they do not pay rent, also known as self-help evictions. Harass a tenant, what a reasonable person believes, enter the property or allow others to enter the property without giving notice, except in an emergency, require a deposit for an assistance animal, medical, that is a medical prescription, cancel an existing lease or the tenants if the building is sold to a new landlord. Now, years ago, before we had landlord and tenant law, landlords used to just throw your stuff out on the street. And that was it. And people were just left out there with no recourse. So it's good that we now have a forum and a set of rules for everyone to follow, not just landlords and tenants. What are a landlord's rights? A landlord can set rules about how the property and common area can be used. They are entitled to having keys to the property. If tenant changes the locks, must give landlord a copy. I've seen situations where tenants have put deadbolt locks on doors and not giving the landlord the key. And if the landlord ever tried to enter the property, particularly in an emergency situation, they're not able to get there. If that happens, the tenant has to remove the lock or provide the landlord with the key. Landlords have the right to evict the tenant if they do not pay rent or do not pay on time consistently, or if they break or breach agreements in the lease. Now, in parentheses, it says a breach can be repaired. There are something that's called a material breach. There are a couple of things that fall under that. One thing is the not paying rent. Another thing is if they find drugs on the unit, or if you are destroying the property. Those are considered material breaches, and courts will certainly take note of that. Now, there are other breaches of lease conditions, for instance. Let's suppose you're playing your music a little too loud. Should somebody be evicted for that? Probably not. The remedy is turn your music down. Okay, that's the remedy. Just turn your music down. Now, if you come back 2 or 3 times for the same thing, it might turn into a serious problem after that. Now, there are other things that are not material breaches that I say the tenant has a right to cure. They use the word a breach can be repaired. It's the same thing. If it's something that is correctable, courts will certainly allow them to correct it before they move toward evicting someone. They must pursue evictions through the court system. Remember, I talked about years ago, decades ago, hundreds of years ago, probably, landlords would just go and lock you out and put you out on the street if you were 1 day late. You know, so now they must pursue evictions through the court system or face some serious sanctions if they do not do that. Landlords may require a security deposit. That's reasonable. You know, security deposit is usually 1 month's worth of rent. So, and landlords are not responsible for a tenant's personal belongings. What are tenants' responsibilities? A tenant's main responsibility is to pay their rent and to pay it on time. Remember, many of these landlords sometimes have mortgages to pay the building off, and they're relying on the rent to pay their mortgage. And if the rent is late, then that means their mortgage payment may be late. And the trickle-down effect is that it could affect their credit rate. Because if they have a mortgage with the bank, you can't go to the bank and say, well, my tenant didn't pay me my rent this month, so can I be late with my mortgage? It doesn't work like that. Oftentimes, landlords have to go into their pocket to pay that mortgage and then hope that it gets caught up when the rent is paid. They must obey the terms of the lease. If the lease states that the tenant must pay utilities, the tenant must get the bills from the landlord. Make sure to get a signed copy of the lease to monitor the rules and terms so you can obey them. I can't tell you how many times I've asked a tenant, did you get a copy of the lease? And they say no. I say, well, did you ask for one at the signing of the lease? Yeah, they were supposed to give it to me, but they never did. Or sometimes they just lose the lease. Leases are to be put in a safe place. Just like some of your other important documents, you should have a lease stored right there. A tenant must communicate with the landlord about
Your Honor, I just want to interrupt. I want to emphasize that because I think that is just so important. And not only if you have a hard copy of the lease, but make a picture, take a picture of it with your phone. We all carry our cell phones now. We have information. Make a folder in your phone that says important documents, and the lease should be in there. A photocopy or picture of the lease. Sorry, Your Honor. Thank you.
You are so right. I used to hate cell phone pictures. But I'll tell you what, I stopped doing that because folks would come in with pictures that are pretty big for exhibits. I could see them. Now, cell phone pictures, they gotta hand me their phone, I gotta blow it up and all that. But you know what? I'd rather have a cell phone picture than nothing. All right, so I'll just go ahead and blow it up and take a look at it. But you need to know what it is that you agreed to. And some leases are 21, 27 pages. A lot of people don't read them. Some pages have to be initialed, as if you did read them, because they're gonna, if you sign it and initial it, you're gonna be held responsible as to if that you did read this lease. So if somebody hands you a 27-page lease, you're not gonna be able to read it in 5 minutes. That means you're probably going to be sitting in their office for however long it takes you to read it, and then go over those terms. They're gonna be hurrying you along. They're not gonna wanna wait that long. You know, particularly if you're in a management office and they have other things to do. Okay, because most people just sign and they keep it moving. The tenant must communicate with the landlord about repair issues as soon as they occur. It is best to do this in writing and keep a copy of the notice. The toilet's running. The water bill's in the landlord's name. You don't say nothing because you don't have to pay the water bill. But yet your water bill used to be $66 and the next month is $366 because the toilet's running and nobody said anything.
So again, you know, with the notifying your landlord of the issues, make sure you keep a copy. So if that's a text message, right, keep that text message. If that's an email, keep that email. You must document everything.
Okay, landlord's responsibilities: maintain the property in good condition, safe, sanitary, and accessible as described by housing codes. Repairs completed in a reasonable time. Not required to pay for repair damage caused by tenant. Multi-unit building, landlord is responsible for maintaining common areas. To meet the safety and cleanliness standards, a landlord must provide drinkable water in the kitchen and bathroom, functioning bathroom with toilet and shower and tub, safe and functioning electrical system, no chipped or peeling paint, hot water, heat during cold months, no cool air required unless written in lease. Let me see. Working sewage system, and there's something on the bottom that I can't see right now. However, those are standards that everybody should live under. If your sockets aren't working, that's a violation. If your heat is not working, that's a violation. And there's a term in the law that judges look at. It's called the warranty of habitability. And the warranty of habitability is a famous case called Pew versus Holmes. You can look it up to see how it all started. But these are some of the things that it covers. And these are the things that have to be in working order. And that is the landlord's responsibilities. Some of the problems that I see is when somebody is in an emergency housing situation and they need a place right now, but the house may not be quite ready yet. And they move in anyway, knowing the conditions of the property. And then they bring that up later because whatever the landlord promised to do, they don't do. Well, technically, the landlord probably should not have rented the space if it wasn't ready to be rented. But landlords oftentimes will rent a space when it's not ready and will not, in a timely fashion, get the place ready for habitability.
Okay.
Landlord's responsibilities continue. The landlord must inform a tenant of lead or paint/lead pipes in the property before a tenant signs the lease. Now, what would tell the story of that? How old the property is? You know, there was at some point in the law, properties could not have lead paint. But if you moved into an older property that predated that law, you still could have lead paint in the property, and it should be tested. Landlord can be sued for triple the amount of damages. If the tenant pays the utilities separately from the rent, the landlord must install separate meters. If they cannot be metered separately, the landlord must pay the utility bill and add it to the rent, and certainly show the tenant a copy of the utility bill to justify what they are charging them. If the tenant tells the landlord that the smoke alarm is broken, the landlord has 72 hours to replace it. That's serious. 72 hours is quite some time to get a new smoke detector. Depending on what kind of smoke detector it is. If it's the kind that you just can go run to Home Depot or Lowe's and grab, rather than the hardwired, where you might need an electrician in order to do it. But they have 72 hours to accomplish that. And we know the reason for that.
Next, Michelle.
Okay, what is the lease agreement? Landlord and tenant law is contract law. Whatever is in the four corners of that agreement is what you agree to. Now, a lease is an agreement between a landlord and tenant that a tenant can occupy and use a property for a certain amount of time in exchange for rent. That's the contract. You move in, you pay me rent. You don't pay rent, you're violating the contract. Be sure to fully understand and agree with its terms before signing. Remember, we talked about those 21-page leases. So if you have questions at the signing of the lease, that's the time to ask those questions. Leases can be oral or written. An oral agreement is technically month to month. An oral lease must have less than a 3-year term. If it is more, the lease must be in writing or there is no agreement. Now, oral leases can be difficult because if it comes to court, who are you going to believe? If it's not in writing, who do you believe? The lease must be written in plain language, no fine print. What that means is none of that legalese. It must be written in a way that the average person can understand it. If the lease is confusing and it gets to court, the judge is going to lean toward the defendant, oftentimes the tenant, because the lease was not in plain language. Now, the lease cannot contain things of what we call unconscionable terms. Let's suppose you have a property and you're renting from a holistic person, and they put in the lease that you must meditate every day at 6 o'clock in the morning in order to move in my space, because they feel if you meditate, you're going to be calm and nothing's going to happen to your space. So they put that into their lease. And you sign it. Does that mean you have to go out there and meditate every morning? If it came to me, there are some things that the courts would consider as unconscionable. That would be an unconscionable term. So for the most part, things that are in a lease are things that can be enforced. But sometimes you may see some language in a lease that may contain an unconscionable term. What can a lease contain? The lease term. What dates is the tenant allowed to live there? Is it a 3-month lease, 6-month lease, 1-year lease, 2-year lease? Repairs, who must make repairs? Smoke alarms, who is responsible to check the smoke alarms? Now that's interesting. I don't think I've seen that in a lease. Visitors, can other people stay for an extended amount of time? That can be an issue. I've seen people come and stay for 3 months and they call themselves visitors. And they may be living in a subsidized unit where the housing entity may want to know the income of all occupants in the household. And if you've got somebody that's living there for 3 months, now it may have been a personal situation. Your sister, for all of a sudden you ended up with her children or something like that. Or your boyfriend's there. I've seen situations like that where the boyfriends have moved in and they keep saying that they have their own place, but they're there all the time and people start complaining. Utilities, who pays for which utilities? Water bill, gas bill, light bill, somebody has to pay for those. And that should be spelled out in the lease. Late charges, what are they? I've seen them as low as $10. I've seen them as high as $200 or more. A late charge, in my opinion, can be unconscionable as well. Now remember, my district covers the Hill District, downtown, and Strip District communities. I have people from zero rent up to $3,000. Some of those high-end units in downtown and in the Strip District are very expensive units. Now, those security deposits certainly would be, and late fees are going to be more than in other places. Who's responsible for snow? Very important. I've seen some leases where I cut the grass, you do your own snow, or I do them both. For the leaves, for the trash. In some leases, there's a waiver of notice to quit clause. Now, remember we talked about that notice that you post on the door, the 10-day, the 15-day, or 30-day notice. Some leases have that waived, and courts have upheld that it's okay to do that. So what that means is that if you're behind on your rent and your rent's due on the 5th, and you have a waiver clause on the lease, they can file a landlord-tenant case on the 6th on you. Now, in most situations, they have to wait 10 days. They have to post a door or either hand it to somebody. Certified mail or first-class mail is insufficient. I've seen landlords, I've seen some lawyers come to court saying that they sent it certified or they sent it regular mail. I said, no, the rules say that you got to post the door. And the rules specifically say that certified mail or first-class mail is insufficient. Or you got to knock on the door and hand it to somebody.
But it's important for you to, so this waiver of notice to quit is often in small print, or smaller print than a lot of the rest of the print in the lease. And if you can cross that off, cross it off.
Yes. Yeah, you have a right to, just because leases are typed very nicely,
Right.
ink pens work wonders when it comes to crossing something off.
Right.
And a matter of fact, a Sharpie even works better. But that notice to quit, and particularly in these long leases. And when I asked for that prior to proceeding in the landlord-tenant matter, and they say the notice has been waived, I said, let me take a look at it. And they just hand me the lease. I said, no. I'm not plowing through all that. I said, and you'll be surprised how often they have to flip through their own lease before they can find out where the notice is. Sometimes it's on page 17. And then they'll check it off and then they'll hand it to me and I'll be able to take a look at it then and see what the language is.
And that's why it's really important for you to read everything in a lease. And if there's something you don't like, you can cross it off. You can talk to the landlord and try to negotiate. I mean, sometimes, yes, you do not have the same leverage and power, but there are some landlords who, for example, there's a health issue for your child. If you need to have, extra electrical equipment or make sure about the new painting before you move in, make sure that it is in the lease so that the landlord has notice of all this. Okay, Michelle.
Okay, resolving issues outside of the court. When any problem arises, the tenant should send a written notice to the landlord. If the landlord does not respond or does nothing, the tenant should send a second notice. Security deposit. The landlord has 30 days to return it. If any money is deducted, the landlord must itemize deductions or the tenant can sue for twice the amount. Oftentimes, now there's a rule associated with that. You have to provide them with your new address. The landlord doesn't know where to send the security deposit. There's a good chance that you may not get it. But they have to also have in order to prevent that, whenever you move or leave a unit, it's good to do a walkthrough with the landlord. If you leave it up to the landlord and they decide on the 29th day that we have all these problems wrong with the unit and they take it out of the security deposit, and then they send you a check that's not the amount that you thought you were getting, that could have been prevented if you had just done a walkthrough the same day you leave, whenever you turn your keys in. Say, I would like a walkthrough, or set up an appointment to come back and do a walkthrough of the unit. Maybe the landlord may be holding you accountable for something that the previous tenant did and they forgot about it. And then when you do a walkthrough in the unit, they say, oh yeah, that's right. You weren't responsible for that or something like that. So it's always.
Oh, and along with the walkthrough, which if for some reason the landlord just hands you keys and can't do a walkthrough, right? I'm going back to the telephone and I apologize, Your Honor, but your phone, when you take a picture, automatically tells you what date it is. So that I would tell you when you first enter the apartment, if you can't get the landlord there, take a picture. Take a picture of a leak in the bathtub. And you will have it automatically dated so that you can then send it to your landlord and say, I moved in today and here's a picture of the leak in my tub.
There you go. And also for landlords, it's good to have pictures of the condition of the unit before someone moves in. Because you could present the before pictures and after pictures if necessary, in court.
Right.
Now, repairs, as was just discussed, take pictures of damage, call 311 to file a complaint with the Department of Permits, Licenses, and Inspections. They do follow up. A health and housing code inspector. Repair and deduct. Tenant makes repairs and deducts costs from the future rent. Cannot exceed the monthly rent amount. Keep receipts and estimates and inform the landlord of this action. Now, that happens once in a while, not very often. But particularly if it's a situation that is causing you grief in your household because it's not repaired and it's something that you may need. It could be your toilet is not working and it's the weekend and you can't get a hold of your landlord, you can't get a hold of anybody. So you have to call somebody in order to get it fixed. And you keep the bill, you pay the bill, and you tell the landlord that you're deducting this amount from your rent. And you have a discussion with your landlord. Oftentimes they will say, well, if you just called me, but I did call you, I couldn't get anybody, and it was late Friday evening or something like that. Okay, what is an eviction? A landlord can decide to evict a tenant for 3 reasons. The term of the lease has ended, we call that end of lease term. The tenant has violated conditions in the lease, the tenant has failed to pay rent. The tenant will receive a copy of the complaint in the mail and instructions to answer. A tenant can file a counterclaim up to 5 days before the hearing. This means the tenant wants to sue the landlord at the same hearing for any expenses such as back rent. Now, what a counterclaim does is it prevents the tenant from having to file a separate case and having to pay the court costs. If you piggyback on the landlord's complaint, the court costs are minimal, and for the sake of everyone's time, we call that judicial economy, your time, you don't have to come back twice. The landlord is hearing both issues at the same, the judge is hearing both issues at the same time, so you don't have to come back and file a separate case. Self-help evictions. When a landlord uses illegal means to evict a tenant, these can include turning off utilities, changing locks, removing a tenant's belongings, etc. All of those self-help measures are frowned upon by the courts. And remember, we talked about earlier, when they used to just change the locks on the door and put your stuff out. They can obviously no longer do that. Okay, going to court. You want to avoid court at all costs. I often say going to court is next to death. Now, in this internet age, the whole world knows when you're in court. And the whole world knows that you got a case. Potential future landlords will check and see if you've ever been to court before they decide to rent to you. Now, certainly, it looks better if you went to court and the measure got resolved. They'll be able to see that too, where the landlord withdrew the case, the judge dismissed it, but there's still a record that you had to go to court. So, if you have to go to court, landlord and tenant law falls under the civil suit. There's a different standard when it comes to a civil case. Beyond a preponderance of the evidence, 51%, all you gotta do is tip the scales. Whereas in a criminal case, you may have heard this term called beyond a reasonable doubt. That is a much higher standard. In a civil case, it's a lower standard. All they have to do is tip the scales. So it's a civil suit between two litigants, a plaintiff and defendant. The plaintiff is the one bringing the case, the defendant is the one being sued. Determines whether the defendant is liable for injury or harm done to plaintiff. Plaintiff must have a preponderance of the evidence when we talked about tipping the scales, and there is no right to an attorney, although people are often represented in landlord-tenant matters and in civil cases. Jurisdictionally, my jurisdiction goes up to $12,000. Yes, I got Judge Judy B. Hers is $5,000. And I say this all the time. She made $40 million from what I understand. I would take that job in a heartbeat. Okay, how a case gets to court. Landlord or tenant perceives a violation of the lease agreement or landlord-tenant law. Landlord and or tenant files a complaint with the Magisterial District Courts where the property is located. There are fees involved with the filing case. It has to be where the property is located. That's a jurisdictional issue. We cannot hear a case if it's not in our district. Now, there are some issues in my own court where there are some jurisdictional boundaries that one district is in one block and the other district is in another block, but they're so close together that it's very difficult to determine whose district it is. And oftentimes, those properties that are located close to another district can get filed in the wrong court. Now, fortunately, we have a computer system that will tell us where it belongs. The wards that I cover are 1, 2, 3, and 5. Judge Riccardi, for instance, has Ward 4. Some of his district is in the Hill District community. So we have to make a determination whenever it's filed to make sure that it's filed in the right district. Also up there in the Oak Hill area, up there. Part of it that is his, most of it is his, but there's a small percentage that is mine. So jurisdictionally, it has to be filed in the right district. The court may have advocates, interviewers to assist in completing necessary forms, but this is not legal advice. Right now, during the pandemic, Allegheny County has advocates attending all of our hearings. I am glad that they are there because they're in the waiting room talking to people before it even gets into the courtroom. So by the time it gets to the courtroom, all the information that they need has already been provided to them. And there are some courtroom observers from other agencies trying to see, how you conduct your court business. If whether or not you are fair and impartial, if whether or not you are respectful in court. People, there are watching how courts are conducted. The plaintiff must then serve the complaint on the defendant. If plaintiff does not serve the defendant or serves the defendant, then the case will be dismissed. Now, plaintiff doesn't have to serve. In a civil case, they're sent out certified from the court. If we get a signature certified mail, then it's considered served. If we don't get a signature, then they can pay for a deputy constable to go out and serve it, and they'll get a signature and serve an adult person in that household. Now, landlord-tenant cases don't have to be served at all. All we have to do is send them out and post the door. The two things, first class mail and post the door. The court will set a hearing date. If the defendant does not show up, the court may enter judgment against the absent party. Now, if plaintiff does not show up, the court may dismiss the case. And at our level, magisterial district courts, if a case is dismissed, it is without prejudice, meaning they can bring the case back. Cases that are with prejudice at the next level, or the common pleas court level, means that you can't bring it back to court. So what they lose is their court costs. So if it costs $180 to file the case, and they forgot and didn't show up and it got dismissed, they can refile the case, but they got to pay another $180 because the court never heard or made a decision on the merits. The case can start all over again. Defendants can file a continuance to move the trial date back, and the court may grant such continuances if justice so requires. These motions must be made in writing and filed at least 10 days before the hearing date. I've approved in less than 10 days, depending on the situations. People often call sometimes the day before the hearing to ask for a postponement. We'll say, put it in writing, they'll fax it over. At least I have something for the folder. Now, if it's too short a date, I may have to not approve it because the other side's going to show up, not knowing that you're going to continue the case. Sometimes I will ask both sides to communicate. Will you contact the other side if they're okay with it, since it's so close to the court date, then we'll go ahead and continue the case. But if it's done in a timely fashion, like the 10 days, then I have time to notify the other side and send the case back out. What a landlord must bring to file a case, their written lease. I can't tell you how important that is. Now, those folks that have one property or two properties, it's easy for them to do that. But if you are a housing entity and you have multiple properties and you have 15 cases that day in court, you should be coming in with 15 leases. I don't care if you have to get a wagon and pull everything out. I'm sure it's inconvenient and uncomfortable to carry all those files. Of everything that some of these entities have very thick folders and files, particularly if you've lived there for years. They should bring that with them. Housing inspection license if operating a multi-unit building. Now that's interesting. I don't think I recall seeing one of those. A copy of the notice to quit unless the lease waives this notice. I require to see a copy of the notice to quit. I asked them to bring it to court with you and let me see what you posted. Because here's what I want to know with that notice to quit. Is it a 10-day notice for drugs or for rent? Is it a 15-day notice for breach of a lease condition, or is it a 30-day notice because you're not renewing the lease? I want to see what kind of notice that you posted on the door, because that may make a determination as to if whether or not I will give the client an opportunity to cure. So, unpaid utility bills that the lease requires the tenant to pay them, that's important too. Oftentimes, the landlord will just say, "We owe me to such and such in water, well, let me see the bill." And then I will ask, "Did you pay the bill?" Because oftentimes I will not reward utility payments to landlords who have not come to court having paid the bill. Who's to say that once the bill is paid that they're going to apply it to the utilities? So, but if they bring the bill and they can show that they paid the bill, then that puts the landlord in a better position. Photographs of alleged damages, that's very important too. Some damages you can't hardly see, particularly if you're not taking a good picture with your cell phone. Other damages you can see very clearly. Proof of payment, invoices and estimates, communication between parties about any damages, alerting the landlord, letting them know in advance that there has been a problem. When in doubt, bring everything. Remember I told you that that big folder that they have, some of the housing entities, instead of bringing the lease, just bring everything in the folder. And that way everything is there. What a tenant must bring to file a case. To sue for repairs, habitability, we talked about habitability, running water, etc. The written lease, you should have a copy of that lease. Do not leave that office without one. Pictures of the conditions, notices to the landlord of the conditions. Remember we talked about putting things in writing, letting the landlord know in advance. Pictures. To sue for a security deposit, you must have a copy of the written lease to show that there was a landlord and tenant relationship. Have a receipt showing that you paid your security deposit. And that's something we didn't talk about. Whenever you pay your rent, they should be giving you a receipt every month, or there should be some record. If you're doing it through Cash App or Zelle, that's a record. Okay. If not, the old-fashioned way, have them write you out a receipt or email you something. Documentation that the key was returned and forwarding address was provided. There should be a document in every folder of any tenant that shows that they returned their keys and that it is signed off on, that the key was returned on such and such a day. Those are suggestions that I have made to landlords many times. Documents from the tenant to the landlord demanding the return of the security deposit. And when in doubt, bring everything with you. Who has the power? Judges. Rulings are binding, but may be appealed. I've been on the bench for 26 years. I don't expect everybody to agree with me. Court staff can direct people where to go and enforce court etiquette and rules. Lawyers provide access to the judicial system. Pro se parties, those folks who are representing themselves without a lawyer, may be able to request to record the proceeding. Security can remove unruly individuals from the courtroom. I have several deputies, one that's in the courtroom at all times. They are armed, and they are there to assist in providing order and decorum. They know what the rules are. They know what you should look like upon entering a courtroom, and they make sure that those rules are followed. The courtroom is a public place, meaning anybody can come in. However, all people are allowed to observe judicial proceedings. All parties should treat each other with respect and with courtesy. Now, certainly during COVID, we try to limit the number of people that we have in the court. And we try to make sure that they are at least 6 feet apart and that people have their mask on, like you all have today. And I have, but I'm 6 feet apart from you. Obtaining a stay of eviction. If a judge has granted a landlord an order for possession, a tenant must file a notice of appeal within 10 days to deposit an eviction. That is so important. I have a case right now pending. A lady hadn't gotten rent in 18 months. English is not her first language, so I have to do a lot of explaining to her. During the pandemic, the last 2 times, the defendant did not show up for the procedure, and I finally awarded her her place. plus all the back rent. Now, the defendant had been following through with respect to the CDC guidelines and all of the financial resources that are available, but she didn't show up twice. So now she lost her case. Well, she went down and filed an appeal. I was at the window just yesterday explaining to the lady that this has to go to another court now. You should have seen the frustration on her face. She hasn't gotten rent in 18 months. And now she has to go to another court to hear this all over again. I said, well, the good thing is that, you know, you're still in place to get your money because the case is still open. It just got to the point where all she wanted was her money, her place back. It seemed like she was almost willing to forget the rent. Now, but you got to do it within 10 days. If a tenant does this, they must pay their monthly rent into an escrow account. So in other words, they don't let you appeal for free. If you have a judgment that you lost at our level in court, they will make you pay 3 months back rent or the judgment amount, whichever is less, in order to appeal. They don't let you just sit there not having to pay your rent. So the tenant must find out how to do that and place their money in an escrow account. This is a separate bank account that shows you are still able to pay rent while the appeal is taking place. If the tenant wins the appeal, the tenant will stay the landlord and will receive the money. So in other words, the money that's in escrow that the tenant was paying, if the tenant wins, the tenant will get that money back. If a tenant is low income, they may qualify for an informal pauperous waiver. This waiver allows the tenant to pay 1/3 of the monthly rent into an escrow account. So if your rent is $500 a month and you have a $2,000 judgment, 3 months back rent would be $1,500 that you would have to come up with. 3 months back rent or the judgment amount, whichever is less. $1,500 in that case. So what if you can't afford it? Well, the Supreme Court has ruled that your financial position, if you are poor, that should not stop you from being able to appeal the case. And that's what informal pauperous means. So there is a waiver that you can sign, and if they approve it, instead of having to come up with that $500 or $1,500 in order to appeal your case, they will allow you to come up with 1/3 of that. And they will give you dates as to when the other payments have to be made in order to keep your appeal alive. So they may
And
say,
many
okay,
of the, sorry, Your Honor, many of these forms are available at the courthouse. Some are available online. People at the courthouse in the clerk's office are willing to help you fill out the forms, but you need to, you can't just assume that it will be granted. You will need to fill out a form to ask for an informal pauperous waiver, and you actually may need evidence of your income or lack thereof.
and I'm glad she's here to talk about that, because once the case leaves our jurisdiction or leaves our office and goes downtown on appeal, it is what we call a de novo hearing, meaning it starts all over again, brand new. So their rules are their rules. Now, if a judge has granted a landlord an order for possession, the tenant must file the notice of appeal within 10 days. We talked about that. We talked about the escrow account. Now, we talked about the waiver, and it must be payable within 20 days. The amount that the Department of Court Records requires you to post. The other 2/3 will be made payable within 20 days. Appealing a decision, if a landlord or tenant wants to appeal the decision, they must file a notice of appeal with the Department of Court Records. That's down in the Civil Family Division, or with the pathonetary. Some folks still use that term, pathonetary. We used to. It's now called the Department of Court Records. I think outside of Philadelphia, they still use the word pathonetary. If a money judgment was entered, either party has 30 days after the judgment to appeal. Now, that's different than the 10-day appeal for when they want possession. So you have two appeals. One is 10 days to appeal for the possession of the unit. The other is 30 days to appeal if you do not agree with the money judgment amount. If an order for possession was issued, an appeal must be filed within 10 days. The notice of appeal will be served on the other party. Once they receive the notice, they have 20 days to file a response. The appeal will be scheduled for a mandatory arbitration hearing. This means a panel of lawyers will act as a judge and will hear the case and evidence de novo without knowing the decision of the previous court. So an appeal for a landlord and tenant case goes down to what is called arbitration. It's not the common pleas court yet. There are, I think, 9 rooms down there. 3 lawyers are in a room. You have to get 2 of the 3 lawyers to agree with you. If you get them to agree with you, then that decision is binding. Whoever is not happy with that decision can then appeal to common pleas court for a trial. The arbitration panel will reach a decision. If any party is unhappy with the decision, they can file a notice of appeal of the arbitration award. And this case may then go to the common pleas court for trial. All right, COVID moratoriums. We are still in a moratorium. There's a federal moratorium effective through October 3rd, 2021. That is the CDC order. You can look that up and take a look at it. But the 5th Judicial District, which is the district that I sit in, our president judge, the Honorable Kim Clark, filed a motion to the Pennsylvania Supreme Court asking that the moratorium for Allegheny County now be extended. The CDC moratorium certainly is in effect, but after October 3rd, when that moratorium is over with, Allegheny County has gotten permission from the state Supreme Court to continue through October 31st because of its concerns with the uptick of the coronavirus, particularly as it relates to Allegheny County. And I believe when you look at the time period, now you can actually go into the COVID-19 integrated county review to figure out what is going on in your own county. If you live in Allegheny County, you click on Allegheny County. If you live in another county, you click on that county. This site provides an integrated county view of key data for monitoring the COVID-19 pandemic in the United States. For the most complete and up-to-date data for any particular county or state, visit the relevant health department website. So in our county, right here in Allegheny County, from the time period of August 23rd, 2021 through Sunday, August 29th, and that was just 2 days ago, the community transmission has been considered high. Cases, 1,942, percent positivity, 5.05%, 11 deaths. Percentage of eligible population fully vaccinated, 64%. New hospital admissions, 197. I'm pretty sure in her motion that that was part of Judge Clark's concern in getting the Supreme Court to approve her motion and extend through October 31st the moratorium with respect to back rent cases and end of lease term cases. So every day we're trying to determine if whether or not a case can proceed or if it cannot. Now we know that if a person has gotten funding started, courts can extend those cases out during the moratorium, allowing the time to take place for those applications to be processed and for landlords to be dispersed their money. Now I've seen money dispersed $8,000, $9,000, $10,000 already. Now, the county received $80 million for the programs to disseminate these funds to those people that qualify. I believe out of the many people that have thousands who have applied, only 100 were turned down, but they've only used 21% of those funds. So part of Judge Clark's reason for asking for the extension was to allow more time to process these applications because they still have $60 million in order to give away to the landlords. So, and it was approved. So in Allegheny County, the moratorium has been extended through October 31st of this year as it relates to back rent issues and end of lease terms.
So this is very important for everybody. For the court to to grant a stay, right, you need to file an application for rental assistance relief through the Coronavirus Relief Fund. That's the website that you can fill out that application. There are people around to help with this application, but it's really important, as Judge said, there are monies available. So we need to have people fill out these forms to get the monies to them.
Now, part of what I'm seeing are what happens with those when the people don't fill out the forms. That's a big deal. The money is available, but if you don't fill out the forms, the landlord's going to keep coming after you. And there are some people that we know that are taking full advantage of the situation. They're not filling out the forms or not following through completely, and they're just sitting up in their units, not paying rent. And some of them have been going on for quite some time with that. The landlords may have to execute a remedy. And if they keep coming back to courts like mine, saying, Your Honor, they have not done anything to move this forward, they have to, the tenant has to provide proof that they are continuing with the process. One good thing is that Allegheny County, through the Department of Human Services, has people in the courtroom. And they can tell me, they can look up a person and tell me what stage that person is through the process. I think when you're at stage 4, you're very close to them cutting a check. So, but you just cannot just sit back and not take advantage of it. Now, if you think the forms are too complicated, there is help available to help you fill out the forms. But we are in a unique situation. We have never before lived through a pandemic, and we have never before faced in my lifetime a situation where government funds are available to ensure that people are not put out on the street because of back rent situation that was directly affected through the COVID-19 crisis. Many jobs have been affected from the COVID-19 crisis, so therefore the government has stepped in. They do not want people in unsafe situations, in situations where the number of people are infected even more because people are being evicted, placed in family members' homes, placed out on the streets, and therefore we're not being able to get the COVID-19 virus under control.
So I have also seen instances where landlords are actually helping tenants fill out these forms. So, it's to the landlord's benefit, right? That the tenants fill out the forms and get the ERAP funds. So sometimes a landlord will help you fill out the form. The biggest and most difficult question to answer is the income. So that if you have, an income tax form or some type of receipt of from the Pennsylvanians taxes or federal taxes, that really will help you complete the application.
And that is very important because the application process does include language about unsworn falsification to authorities. It's a criminal charge if you lie. Okay, to lie on an application in order to be able to receive funds, you can be charged criminally if they decide to investigate that and take a look into it. Well, we don't want to lie. We want to tell the truth. We want to be able to receive help because you're out of work and it's been directly related to the pandemic. You can show that, and you're unable to pay your rent, and you don't want to be out on the streets. So, well, that's it for me in terms of my presentation. If there are any questions, I'll be happy to answer them as best as I can.
I have a question. Hi, I don't have a question. I just want to let everyone know that landlord could apply for that money as well. There's been a lot of back and forth about that. And we also, our group, CURB, We're the ones that's working in the courts with Allegheny County.
Okay, can you identify yourself and tell what organization you're
Yeah.
from?
Oh, I'm sorry. My name is Carol, Hill District Consensus Group, and also a member of HER, which is the Pittsburgh-Tenant Regional Group. And so we've been working with Allegheny County. We also have been working, helping people apply to rent relief and so on, more on the tenant side. But I just wanted to say landlords can apply for that money as well. You know, if the tenant may not know how, or, you know, they have an opportunity to apply for funding as well. So it's a two-way street.
My name is Pauline Long. I'm coming asking a question. I wasn't aware that there was money available in the state of Pennsylvania, but I'm aware of someone who is in need in another state. Is that federal money and is it in other states also?
Absolutely, absolutely. It's all over. We got 80 million in Allegheny County. I don't know how many counties there are in the state of Pennsylvania, but there are quite a few. Each county is allotted, it probably is based on population and that sort of thing, but each county is allowed.
For you to find out what resource, just Google federal rental monies, you know, for COVID and put the county in even, and that might help you find that application, because it is, as the judge said, it's available across the United States and across the Commonwealth.
I'm Ebony Jackson, and I'm with Wisdom and Way. The question that I have is pertaining to as far as if you go to court, if the tenant is going to court for a tenant landlord complaint, and the tenant would like to appeal it, you were speaking of the money that they would put into the escrow account. They would have to pay for the appeal. So would they pay for that appeal through the escrow account, or they would have to pay a fee until the appeal is over, and then they determine what will happen with the money that's in escrow?
Well, based on my understanding, escrow accounts are usually set up whenever there is a problem with your unit. For instance, it's a violation of the warranty of habitability for something. One of the violations, your furnace isn't working, your light, your electricity is off, your water's not working, something like that. And you call the health department in, they come in, or there are rodents in your house. And the health department says, yeah, this is a problem. Then you can place your money in an escrow account through the health department if they still do that. Now, the other one that you talked about, which if somebody appeals the possession, which is they have 10 days in order to do that, that would be because they lost at the court, and the court determined the landlord gets their back rent. So they don't want the appeal process to stop the defendant from paying their rent.
Okay.
So what they will do is they will make the defendant pay 3 months back rent or the judgment amount, whichever is less, or if you are indigent, they will place you on a payment plan because they want you paying something while you are waiting for your appeal.
Okay.
So particularly in situations where your appeal is going to go into the next month and rent's going to be due again.
Okay.
So that court holds that money down there.
Okay.
And then once the appeal is over, if the landlord prevails, that money is released to the landlord.
Okay, and they would have to go downtown to actually open the escrow account.
Well, they would have to go to the Department of Court Records.
That's what I think. Okay.
Department of Court Records and appeal the case first.
Okay. Okay.
And then they will walk you through the process once you've done that.
Okay. Sounds good. Thank you.
You're welcome. Now, Farrell had mentioned that the landlord can also apply for funds. I'm just, that's a great thing, but I'm wondering if whether or not there is a signature from the defendant side or the tenant side in order to get the landlord's application moving. So I would think that at some point there has to be cooperation from the tenant as well. And I think where some of the landlords are running into some problems is where the tenant doesn't follow through with the available funding resources. And what remedy do they have in order to make that happen? I would say for a landlord, just bring it back into the court and force the defendant to show that they are moving forward with the process.
Okay. Deb, can we get some questions from those who may be online?
She's unmuted herself.
Real quick.
You're
comment.
mute, Debbie, you're muted.
There aren't any questions online, so if people want to put some questions in the chat, that's fine. We've been trying to answer them. Oh, well, actually, that's not true. Okay, so there's, when living in low income or Section 8 housing and utilities get turned off, is this grounds for an eviction?
You're living in Section 8 housing and utilities get
Turned off, is this ground for an eviction?
because the tenant didn't pay the utility bill and the utilities are in the tenant's name. That's what I'm going to assume.
That's what I'm assuming.
Yes. In my opinion, yes, they can bring a case against you because let's suppose it's in the wintertime and your utilities are off and the gas is not on and the pipes freeze and cause damage to the property. It also can cause damage to the property next door if it's an attached property. I would say yes, that the landlord has a right to bring a case if the utilities have been turned off, because now that the home is not habitable and the landlord is knowingly renting his place that is not habitable because it doesn't have the utilities on. So they would probably, in order to protect their own interest and others around them, to bring a case.
Michelle, do you want to follow up? Are you okay with that answer?
Yes, I will follow up.
No, wrong Michelle. There's another Michelle.
Oh, okay.
Yes, because the reason why I asked that is I called the utility companies to find out they really don't have anything to do with an eviction when your lights get cut off. They're just gonna make some kind of adjustment for you to pay your bill, but it seems like the landlords are just putting you out without even finding out what's going on. So that's why I asked you that, Judge.
Okay, so it's not that you are it's not that the tenant was responsible for paying, it's that the landlord was responsible
Yes.
for paying.
Yes.
Well, the tenant would then have a cause of action against the landlord,
Right.
particularly for the violation of the warranty of habitability.
Exactly. But we've been finding out that's not the case, and they put it on the resident and they do it an illegal eviction. So I just need to know so I can help my residents.
Well, what does the lease say? As far as
The
the
lease
utility,
really doesn't say anything about utilities being shut off.
who's responsible for the utilities? The landlord?
The landlord,
It's a violation of the warranty of habitability if the landlord is responsible for the utilities and they don't pay it. You can bring them to court and force them to show otherwise.
okay.
You know, the utility company cannot stop you from bringing someone to court. You can bring your landlord to court, most definitely.
Thank you.
You are welcome.
So I have to actually head out, but there was one other question on the chat from Brenda Harris. Brenda, are you still on? Do I see you? I don't see you.
No.
Okay, are there any other, I apologize, I actually have to leave, but I'm gonna pass this over to Michelle, and I wanna thank everybody for joining us. And if you have any questions, please don't hesitate to reach back out to PMC, but I'm not ending this event, I'm just heading out. Thank you.
Thank you, Debbie.
I don't speak dog, but I'll try to answer.
Perfect timing. So if the question from Brenda, I don't know if anybody else wants to have the answer, but is there a standard for maximum late charge amount before being deemed unreasonable?
Well, I have actually told landlords that that's too much. And usually I will base it on whatever the monthly rent is and force them to show me how they calculated it. And I want to see the language in the lease that spells out how it's to be calculated, because the tenant should know how late fees are calculated just based on what the agreement is in the lease. Now, a $50 late fee to me is reasonable, and usually that language is in the lease. It's these leases that take a percentage and then try to use the number of days that you are late to tack on to that number in order to determine what your late fee is. That number can end up being an astronomical number, particularly if somebody doesn't pay their balance in full, they're carrying a balance. So therefore, there's going to be a late fee each and every month. So I deem it unconscionable for late fees to get above a certain amount, but it's usually depending upon what your monthly rent is in the first place. If you're paying $500 a month or if you're paying $3,000 a month.
Are there any other questions before we end session?
Somebody texted me an answer to her question.
What was her question?
It said, I don't know who it's from, it says there's an in-house lawyer here, legal aid, that has office hours, so you might want to talk to the.
Right in the building?
Outside.
In this building?
Yeah.
Well, perfect.
And, he does the Hill and Humble.
Do they do landlord-tenant? This legal services lawyer does do landlord-tenant law?
Yes.
Okay.
I think this is someone from Neighborhood Legal Services, so they have an in-house staff person here.
Well, neighborhood legal services were in my courtroom regularly, and I think their funding got shut off, and so therefore they couldn't come. But the cases went a whole lot easier when they were there, because there's a lawyer in the courtroom representing the tenants.
There,
Some, as a judge, I would,
neighborhood has special funding that works out of the Hill in the Homewood CEC, that if cases come through Homewood, Adam would come to your courtroom in the Hill. But we only have a limited, we lost all of the CARES funding. But yeah, we have funding for the to operate out of the Hill CEC. So Adam's there on certain days or by appointment during the pandemic, I believe. But
Yes.
the lady at the desk would have his card.
I see him, but not as much.
That's why we need right to counsel. I'm on, look, I'm not on, but we need a right to counsel for tenants. It's real good to have all these laws.
If there are any more questions?
Yeah. Well, we want to thank you so
Well,
much.
thank you all. I mean, this is my first time doing it this way. And certainly, we can tweak our game a little bit to make sure that we get done in a certain amount of time in order so we can field the questions. Because the questions to me are more important than my presentation. You know, so.
Thank you so much, Judge Petite. This was wonderful. We had quite a few folks online, so I will share their contact information and also any other questions that they might have.
And if you want to do it again, I'm sure it'll even be better the next time.
Yes.
But so just keep us posted. Thank you to the Pittsburgh-Mon Valley Black Women's Roundtable, Reverend Dr. Judith Moore, and all of those folks who are listening virtually and the folks who are here in the space that I am in right now. I am Judge Oscar Petite. Thank you.
Thank you.